Welcome to another edition of Florida Appeals Journal. I'm Jennifer Carroll. And the question we have this week is, what do you do when a trial court refuses to carry out its duties under the law? Say, like the trial court, for whatever reason, is refusing to conduct a hearing, or the trial court has not issued a ruling for, it's been a year, for example, something, outrageous. What's your remedy for that? Well, what your remedy is to invoke the original jurisdiction in the appellate court, in the district court of appeal, for example, when you're coming from a circuit court, and you would file an extraordinary writ. The writ is a writ of mandamus. So it's important to understand exactly how mandamus operates, when to use it, how to effectively use a petition for writ of mandamus. It's because you have all sorts of problems, all sorts of issues can come up in a case in the trial court at any time, but all is not lost. So when you have non-standard issues and particular issues, you can challenge them at the appellate level. It's not necessarily an appeal. They don't call it appeals. You don't have briefs, but it's an extraordinary writ. So here we're going to talk about mandamus. And what does that mean? All right. Mandamus is a common law remedy, right? It's used to enforce an established legal right by compelling a public officer or an agency to perform a duty required by law. All right. So like other original proceedings, there's prohibition, cert. We've addressed some in the past. We'll address some in the future. You're going to follow Rule of Appellate Procedure 9.100. That lays out a lot of the procedures that you'll need to follow, and we'll go over that. But when talking about mandamus, one of the fundamental principles for issuance of a writ is that the legal duty that you're talking about of a judge, a public officer, a public agency has to be a ministerial duty, it can't be a discretionary ruling with the entity. Now, a duty or an act is defined as ministerial, quote, when there is no room for the exercise of jurisdiction and the performance being required is directed by law. All right, so mandamus has to relate to a ministerial duty that the underlying agency or court is simply not doing, and they should be doing it. So you would do a petition for mandamus. If there is another adequate remedy, you need to use that. But if there is no adequate remedy, then you use the extraordinary writ of mandamus. All right. Now, and administrative law, of course, and this is really what that requirement is going to, the doctrine, you have to exhaust your administrative remedies, of course, before going to court. So that's when that principle will kick in. Private rights between individuals, legal obligations, have no place in mandamus. Okay, that's just straight appeal. You have to deal with that through your regular course of appeals, of a standard appeal, for the most part, depending on the individuals. And then that's another topic when you deal with the CEOs and certain corporations. Now, what are some examples? All right, well, I gave you a couple in the beginning. A court is refusing to hold a hearing that, hey, your client, are perfectly entitled to, but the court refuses to do. That's an example. One of the most common uses is the filing of a petition to force a public official to issue a license or a permit. So let's say a petitioner, you meet all the qualifications for issuance of a building permit. The appropriate government official has no discretion to deny the permit. So if it's a ministerial duty to issue that permit, mandamus is often used for that purpose. And now, another use for mandamus is to test the correctness of an order determining that a court lacks jurisdiction. So you can have where the trial court dismisses a case claiming it doesn't have jurisdiction, but you're saying, hey, I think I'm reading the law this way that, yeah, you do have jurisdiction. So you can do a petition for mandamus to challenge that. Other examples, you can compel a trial judge in a criminal case to grant a preliminary hearing to an accused. And we'll be putting cites also as part of our journal entries and on the website that supports the mandamus petition. You can also do a petition for mandamus to a trial judge to submit to a jury the issues that are triable by tribal as a right by jury. You can also compel a trial judge to enforce a foreign state child custody decree, compel a trial judge to exercise jurisdiction, as we stated, and compel a district court of appeal to reinstate an erroneously dismissed appeal. So there are lots of examples, and we'll try to cite some of them again with this topic. Now, remember, the trial judge is not to be named as a respondent in the caption of a petition for a writ of mandamus. Now, that's important. You do that, you're going to get a kickback. So even if you're directing it to a trial judge to enforce a ministerial duty, the trial judge does not get named. Now, you will include it in the body of the petition, and you'll also send the judge or the underlying agency a copy. And usually how it works is any of the parties to the proceeding that are opposing your petition, they can go ahead and respond, all right? And the judge can, but 99.9%, they're not going to get involved in that. But they certainly have no duty to respond to your petition. So that's just a very key point, because a lot of times people will include that, and it's not appropriate to do, so you want to avoid that. So initiating review, again, I refer you to Florida Rule of Appellate Procedure 9.100. It tells you, it's an original proceeding, so you don't need to file anything in the lower court like you do in a regular appeal. You file a notice of appeal first in the trial court, and then that goes up to the appellate court. But because these petitions, these extraordinary writs, really invoke the original jurisdiction of the appellate court, so you're going to file it directly with the appellate court, and the filing fee is typically the same as when you file an appeal. So I think for mandamus, I think it's still $300. As an example, you double check, but just like when you would do an appeal. Now, remember too, there is no time limit for a petition for mandamus. And actually, for many of the extraordinary writs, of course, certiorari, you've got 30 days, but generally for the others, and we're talking about mandamus today, you don't have the 30-day time limit, but you still want to move in an expeditious manner, because if you wait too long, the court may say, doctrinal laches, we're not going to grant you relief. So keep that in mind. That's a very important point. And you don't file a record like you do with an appeal. So you're not really involving the clerk and directions to the clerk and having the clerk send anything over to the appellate court. What you are going to want to do, and again, these are detailed in Rule 9.100, but you're going to want to file an appendix, okay? An appendix containing documents from the record that are relevant to your issue in the petition. You'll attach that. And remember, when you do your petition, and it's not a brief, okay, people do get this mixed up, but it's a petition, you're going to want to look at that as your last chance to get everything in front of the appellate court that you want, because it's not like normal appeal. You brief, you get your answer brief, you got your reply. But you're not going to have a chance, because if you want to show the court that you have a prima facie case, so to speak, that you can make a preliminary showing of entitlement to the relief you seek. So you got to put everything in that you think is important at that time, because what you want is the court to issue an order to show cause, and then the court will issue a scheduling order. And they'll do an order to show cause. We think petitioner has made out a preliminary case. I call it a prima facie case for relief. So there's an order to show cause why the relief sought shouldn't be granted. And then they go ahead and set a schedule for a response to the petition. And then you'll get to reply, but only in those circumstances. So that's generally how it works, contents, your exact contents for the form. Also, you look in the rule again. You're going to want to state your basis for invoking jurisdiction of the court, the facts you rely upon, the nature of the relief sought, always important, helps the court out quite a bit, and the legal argument, of course, with your citations of authority. And you'll want to provide that. And again, the preparation of the appendix, you're going to want to meet the requirements laid out in Rule 9.220. And I've seen cases thrown out, they'll deny it if you don't include the relevant materials in your appendix. So keep that in mind, that the appendix can be very important. You want to make sure it is sufficient. Okay. And let's see. Then on the record, we've explained that. And the response, the rules on that now. So that's in a nutshell how petitions for writ of mandamus work. So the bottom line is, go to that rule. You can do a search if you want to find some cases maybe similar to yours. But the key is, are you dealing with a ministerial duty? And there's really no adequate remedy, especially something that's really going to be causing harm to your client, to the party involved. You definitely want to do that. So when you have wacky things happen in the trial court, and I call these non-standard, they're not your typical, they're not the type of things you really can take an appeal from at the end of the case, or it doesn't qualify even as a non-final appeal because those are laid out in the appellate rules under their own section. Just remember, there are remedies, and really through the use of extraordinary writ. So it's really important for each practitioner to have a handle on how these extraordinary writs work, so that when something comes up, a light bulb goes off in your head and says, wait a minute, there is a way that we can address this issue, and you'll want to go ahead and move forward in an expeditious manner. That's it for this week. Any questions, as always, please let us know. Thank you, and we'll see you next time. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.